When companies fail and investors lose money, some of the first questions asked are who are the auditors and should they have caught the problem sooner? This topic is not just about memorizing cases. It's about understanding who can sue an auditor, under what legal theory, and why auditor liability differs depending on the relationship between the parties. By the end of this lecture, you should be able to look at a lawsuit and identify who is suing, does privity exist, which legal theory applies, and how much exposure the auditor faces. Almost every audit lawsuit comes down to one core issue: duty of care. The auditor's duty is strongest to the client, weaker to third parties, and broadest only in cases involving fraud. Whether the plaintiff can recover damages depends on the legal theory, meaning common law or statutory law, and the relationship between the auditor and the party bringing the lawsuit. Common law develops through court decisions, not legislation. Under common law, auditors are expected to perform their work with the same skill and care as other competent professionals in the field. And when auditors fail to meet that standard, they may be liable, but the level of liability depends on how serious the failure was. Simple negligence, gross negligence, and fraud are treated very differently by courts, especially when third parties are involved. When auditors are sued by third parties, courts ask one central question: how far does the auditor's duty of care extend beyond the client? Different courts answer that question differently, and that's why we have 4 approaches. Under the privity approach, if you didn't hire the auditor, you can't sue for negligence. A landmark case is the Ultramarys versus Touche case from 1932, which is pretty interesting that over 90 years later, this is still the landmark case. In this case, Ultramarys Corporation, a lender, had provided a loan to an importer based on audited financial statements from the accounting firm Touche Niven and Company. When those statements were later revealed to be erroneous, the lender sought recovery from the auditing firm after failing to collect from the borrower, who had been insolvent at the time of the audit. Judge Benjamin Cardozo ruled in favor of Touche, asserting that imposing liability on auditors for all third-party users would create an excessive burden and lead to uncertain legal consequences. However, he did establish that accountants could be held liable for gross negligence akin to fraud. Under the near privity approach, basically you can sue only if the auditor specifically knew you would rely on the audit. Auditors must have known the purpose of the audited financial statements, the users, and the reliance they'd place on the financial statements. The Credit Alliance versus Arthur Andersen case established tests for holding auditors liable for negligence to third parties. First, the auditor must have acknowledged that financial statements were to be used for a particular purpose. Then there must be an intent of the third party to rely on the financial statements. And third, there must be an action linking the accountant and the third party that proves that the accountant knew of the third party's reliance, like in the Credit Alliance case, where there was communication between Credit Alliance and Andersen. Subsequently, in the 1992 case of Security Pacific Business Credit, Inc. versus Pete Marvick, Maine and Company, this last requirement of an action that links the auditor to the third party was even more emphasized in that it stated that the third party must be known to the auditor. The near privity test here is that the auditor must directly convey the audited report to the third party, or the auditor acts to induce reliance on the audit report. The actually foreseen approach is a middle ground approach where if you weren't named, but you were part of a limited group the auditor should have expected. The landmark case here is Rouge Factors versus Levin and Second Restatement of Torts. In Rouge Factors, the court held that an auditor could be liable to a lender even though the lender wasn't the audit client, because the auditor knew the financial statements were being prepared to help the company obtain financing. The lender didn't have to be named specifically. It was enough that the auditor knew a limited class of lenders would rely on the audit. The second restatement of the law of torts approach, sometimes known as Restatement 552, expands accountants' legal liability exposure for negligence beyond those with near privity to a small group of persons and classes who are foreseen or should have been foreseen by the auditor as relying on the financial information. This is known as the foreseen third-party concept because even though there is no privity relationship, the accountant knew that party or those parties would rely on the financial statements for a specified transaction. The reasonably foreseeable approach expands with the Rosenblum versus Adler case, where the court ruled that auditors should be liable not just to known users or limited groups, but to anyone the auditor should reasonably expect to rely on the financial statements, such as investors in the open market. Basically, anyone the auditor should reasonably expect to rely can sue. The reasonably foreseeable third-party approach results from a 1983 decision by the New Jersey Supreme Court in Rosenblum Inc. versus Adler. The New Jersey Supreme Court ruled that auditors should be liable to all reasonably foreseeable third parties who rely on the financial statements and stated that independent auditors have a duty of care to all persons whom the auditor should reasonably foresee as recipients of the statements from the company for proper business purposes, provided the recipients rely on those statements. Another important case that followed this approach was Citizens State Bank versus Tim Schmidt and Company. In this case, the bank sued the public accounting firm after relying on financial statements for one of its debtors that had been audited by Tim. The Wisconsin court used several reasons for extending auditors' liability beyond privity. The Wisconsin court ruled that the cost of credit to lenders would be prohibitive if foreseeable third parties could not sue auditors. Since 1987, though, no state high court has adopted this foreseeability approach to accountants' legal liability, while a large number have approved or adopted one of the narrower standards. For example, in its 1992 ruling in Biley v. Arthur Young, the California Supreme Court expressly rejected the foreseeability approach in favor of the Rouge factors or restatement standard. The court stated that the foreseeability rule exposes auditors to potential liability more than their proportionate share. However, in its 2003 ruling in Murphy v. BDO Seidman, the California Court of Appeals ruled that grapevine plaintiffs who alleged indirect reliance based on what others, meaning stockholders and stockbrokers, told them about the financial statements had legal claims for ordinary negligence against the auditor so long as the auditor would have reasonably foreseen that stockholders or stockbrokers would tell other people of the content of the financial statements and that the other people would rely upon the misrepresentations in purchasing the corporate stock. Here's an example where an auditor issues an unqualified opinion. A bank later relies on the financial statements to approve a loan. The auditor knew the company was seeking financing but did not know the specific lender. Which approaches allow the bank to sue for negligence? Did the auditor have a privity relationship with the bank, meaning a contractual relationship? No, because the auditor's relationship was with the client. So privity doesn't apply. What about near privity? Was the bank known to the auditor as a user of the financial statements? The answer is also no, because the auditor did not know the specific bank or lender. So now the question becomes whether the auditor actually knew that a bank or lender would use the financial statements or have reasonably foreseen that a lender would use the audited financial statements, and the answer is yes. The auditor knew the company was seeking financing, so the auditor knew a lender would rely on the financial statements and also could have reasonably foreseen the lender. It's easy for someone to jump to the conclusion that auditors missed something when a company that receives an unqualified opinion subsequently fails. Of course, auditors can be liable to the company that hired them to audit their financial statements, but also to third parties. And the auditor's duty is strongest to the client, weaker to third parties, and broadest only in cases of fraud. In subsequent videos, we'll cover how the auditor can defend themselves against claims of negligence and fraud.